So guys, now we are in the part 4, the last part of our management and administration. Circulation of members resolution. And the point is, we need to be knowing what type of, what is the way that it is being circulated for passing a resolution. Resolution, we are anyways going to study whether it is going to be ordinary or special. And what meeting, in which meeting it is going to be proposed, whether it is annual general meeting or extraordinary general meeting, we need to know. So requisition in writing has to be there. So to whom it has to be given? The notice to members should be given. As per the Companies Act, the company shall on requisition in writing should provide that what type of resolution will be done, how it is to be made, how it is going to circulate the statement to the members, all that they are going to make it with a proper resolution. As I was already telling you, ordinary resolution or special resolution. Exemption from serving the notice. What is that exemption they're talking about? The company shall not be bound under this section to give notice of any resolution unless a copy of requisition is signed by the requisitionist. Who is this requisitionist? Requisitionist is a person to whom they will ensure that it is properly done, the formal request that is done by the people. So they are called requisitionist, and it will contain all the signatures of the requisitionist deposit at the registered office of the company. The point is not just being signed by the requisitionist. The point is not less than 6 weeks before the meeting, it has to be properly done. So that is what they are talking about, the exemption. If it is properly signed, then it is not going to be a problem at all. So the company shall not be bound to give any notice unless and until it is properly signed and given not less than 6 weeks before the meeting, then it is going to be perfect. So exception from circulation of any statement. When there is any declaration by the central government on the rights conferred, anything relating to which disturbs your public interest, so then they will ensure that the circulation has to be properly done. The company shall not be bound to circulate any statement if there is any aggrieved party or if the central government declares that it should not be done. So for that time and all, they will not do the circulation. Who will bear all the cost? Obviously, company only shall be paid by the by the company. The cost that is incurred by the company shall be paid to the company by the requisitionist. That means first they will bear, company only will be bearing, and beyond that, if they wanted to reimburse, then the requisitionist, that means who are doing a formal request, has to be done, because it is on their own perspective that it is going to be done. If you are not doing properly, then the default penalty provisions is to be done. So based on the central government order, or based on the 6 weeks time, or based on the order of the cost, the penalty provisions will be considered that into the picture. Yes, the point was very simple. For whom and all the circulation has to be done, for whom and all the circulation need not be done. That is the point that they wanted to do. Here we are bringing a concept called requisitionist. That means a formal request that is done by the shareholders of the company. It can be by way of them, or it can be by way of central government order. Guys, I was already talking about the representation of president and governor being a member. If they are the members of a particular company, will they directly come, or will they ask anybody else to come? They will not be able to directly come. As you know, they are the first citizen of India, and governor of a state will be so very tough in dealing up with every particular company's perspective. If he is a member of the company, he will appoint a person who is a representative. It is not a proxy, it is a representative, because they are big people. So they will ensure they appoint a person who is representative, and they will do all the activities based on the rights that is already available to president or governor. That means, please understand here, they will be entitled to exercise the same rights and powers, including the right to vote, to proxy and postal ballot. They can try to have anything related to that postal ballot as the president or governor could exercise as a member. If the president is there, if the governor is there, what they will do, they will have the exact same right. Who will have? The representative will have. Next, representation of corporation meeting of companies and creditors. Now, very simple. Now, when we were talking about the meetings, it can be by way of a creditors meeting also. Can you do that? If the body corporate, can it be a member of the company? Yes. So body corporate can be a member of the company, but individuals only will be directors of the company. So this will be always a confusing point when you cover your final portion. A member of the company, even a body corporate can be there, but for a director only individuals has to be there. So can anybody else represent the body corporate? Yes. Again, a representative will be done by the body corporate, so that they will act as if they are the member of the company, or if it is a creditor, they will, based on that particular resolution, they will have. Very simple point. Yes, they can have representatives will be there. What is the powers and duties? Same way, exercise the same rights and powers, including the right to vote by proxy and by way of postal ballot on behalf of that body corporate. Yes, you can do. So again, a very simple point to complete. Resolutions will cover from 114 to 117. What is a resolution? Resolution is a formal decision of an organization. Okay. When you wanted to have a formal decision of organization while transacting a business at a meeting, it is called a resolution. They will have a differentiate between what is a motion and what is a resolution. Motion means they will ensure that who has a majority vote, who is for, who is against that particular travel that they do it for the decision making is called motion. And once that is all favorable, then what it is fine, then they will put it as a resolution. So there is a very small difference. The point is, whatever that comes before a meeting, that means before a decision making is to be done, approval, disapproval, before that it becomes a motion, and once the decision is taken, it becomes a resolution. So only we say motion is a proposal and resolution is the adoption of that particular proposal. So it is very easy to remember. How many types of resolutions are there? Two resolutions are there. Ordinary resolution, special resolution. Ordinary resolution, simple majority 50%. Special resolution 75% majority. So I will freeze this for a minute and you will understand 50%, 75% only. Based on that only they will say what type of resolution we have it as per the Companies Act. Yes. So ordinary resolution, special resolution. So see this point, simple majority and 75%. Yes. Now let's go and see what is there for ordinary resolution. Ordinary resolution, if the notice required under this act has been duly given and it is passed by the votes cast either by show of hands or electronically or poll or whatever it is, if it is decided by the chairman later, then when the amount exceeds the votes, that means if it is 10 votes, if it is 11 votes, means then it is an easily exceeding the votes cast against it. So in simple words, what they will say, the votes cast in the favor of the resolution by any mode of voting should exceed the votes cast against it. It can be poll, it can be show of hands, it can be electronic means, it can be postal ballot, whatever it is, they will ensure that it should be more than that. If it is there, then it is a simple majority. But special resolution is not like that. Many people, what they say is 3/4 of the votes in favor against the cast means special resolution. No, there are 5 characteristics of special resolution which we should consider. So we'll go one after another. Now, let's not bother inside and see what is the point. Directly we'll go into characteristics so that you will understand the crux of it. Specified majority, 75% should be there. Point number 2, what type of resolution that you are going to pass for what matters should be set out in the notice. Point number 3, notice must state that the resolution is to be passed as a special resolution and omission would invalidate the resolution, because 75% required. No. So we need to be very careful. Normally in company law, they will say pass special resolution general meeting, we will allow. It is not going to be an easy thing, because it should be 75% of the majority that you should concentrate on. Point number 4, proper notice should be sent. What is that proper notice? 21 days, clear days notice should be sent. And along with the notice, you should also annex what? Explanatory statement. We already told, no, before the meeting, what you should be doing? You should send an explanatory statement for the business, and that also has to be provided. Now, when it means the ordinary resolution is to be passed when the company in general meeting, and special resolution should be passed with the 3/4. So same point that they are talking about. What is the notice specifying the intention should be provided by the act. We already told what is ordinary business, what is special business. Now we have told what is ordinary resolution, what is special resolution. So accordingly, you can remember this very, very easily. So ensure that special business is always for EGM. Resolutions requiring special notice. The example that we talked about is already been mentioned. So let's not bother about it. Now we are going inside. We already told what is notice. Now we are going inside the special notice. That means that becomes ordinary notice. What is special notice? Section 115 of the Companies Act states that where any provision requires or AOA requires that there should be a special notice to be passed, you should do it. What does that mean? That resolution shall be given to the company by members holding not less than 1% of the total voting power or aggregate sum not exceeding 5 lakhs. We have already discussed the same thing previously also, which has been paid up. So properly, when it is special notice, you should ensure two things that is to be there. Number one, holding not less than 1% of the total voting power or holding shares not exceeding the 5 lakh rupees as prescribed. For that only special notice to be done. Concentrate really strong. Special notice is required in 3 cases. Number one, appoint auditor other than retiring auditor. A director other than retiring director. 14 days notice. Special notice means 14 days notice. Ordinary notice means 21 days notice to remove a director under 169. So remember 140, 160, 169 for you to keep in the special notice. So special notice rules also is being given. That's what I told you. You remember 14 days it is there. If it is to be even more before that, you can also pass it by 7 days notice. So you can remember it in multiples of 7. First we told 21 days, then we told 14 days. Then you should ensure at least 14 days before the meeting and give the members resolution. If it is as quick, it can also be done at least 7 days before the meeting. The special notice should always be bothering about the 5 lakhs and 1% of total voting power. We have already covered this point. The second point we just now covered, saying not earlier than 3 months, way before 1 quarter before itself, you should not send, but at least 14 days should be there before the meeting. The third point also I told multiples of 7, so 7 days it should be done. And practically it is not to be given notice to the members, so you can publish it in the newspaper even 7 days before that, excluding the date of publication. Yes, you can give. So always remember resolution, always remember notice will be in the multiples of 7, 7, 14 and 21. So this is how you will try to remember. Resolutions passed at the general meeting, that also has to be properly given based on the point. Yes. Now again, the example also is based on the quorum and the ways to provide that in the quorum. So it is not a big deal to be covered. Now we need to cover the resolutions and agreement to be filed. You will have to file everything with ROC within how many days? Along with the explanatory statement, within 30 days of passing, all the resolutions, all the agreements has to be provided and filed with the ROC. That's what they are saying in the extract of the act. Whatever we told now, everything will be there in the extract. So let's try to remember it in an easy way. The one simple thing that we need to cover is MGT 14 has to be done for passing the resolution and providing it to ROC. Yes, same point they will again and again say, let's not bother about that, and we can go to the next level. If there is any if there is anything that if you are not compliance, again the penalty provisions will come into the picture.